What is the loophole that lets her serial killers escape death row? The so-called loophole is not a single trapdoor in the law. It is a bundle of constitutional safeguards and procedural rules that, taken together, can block or overturn a death sentence when the process is unreliable or the defendant is not legally eligible for execution. In plain terms, the system demands extraordinary accuracy before the state can take a life. When those safeguards work, critics shout loophole. Lawyers call it due process. A quick origin story helps. Modern death penalty law in the United States grew out of constitutional battles over cruel and unusual punishment and the demand for heightened reliability in capital cases. Over decades, courts narrowed who can be executed and how. Juveniles are categorically excluded. People with intellectual disability are categorically excluded. The insane cannot be executed, and a person must be competent at the time of execution, meaning able to rationally understand the punishment and the reason for it. These are not indulgences, they are bright-line rules grounded in human dignity and the risk of irreversible error. So what are the mechanisms that critics label a loophole? Start with mental status. If a defendant is incompetent to stand trial, proceedings pause until competence is restored. If a condemned prisoner later becomes incompetent, the execution cannot lawfully proceed. Severe mental illness can also flood the penalty phase with powerful mitigation. Brain injury, psychosis, trauma, or cognitive impairments that diminish moral culpability. None of this excuses serial murder. It limits the state's power to execute when the law's thresholds are not met. Next comes ineffective assistance of counsel. Capital defense is specialized, and when lawyers fail to investigate mitigation, ignore neuropsychological red flags, or botch jury selection, courts can set aside a death sentence and order a new penalty phase. To the public, this can look like a technicality. In reality, it recognizes that life or death punishment demands competent advocacy. Prosecutorial misconduct is another pathway. If the state hides exculpatory or impeaching evidence, uses junk science, or invites an unreliable identification, a conviction or sentence can fall. The rule is simple. The government must play fair when it seeks the ultimate penalty. Likewise, flawed jury instructions, invalid aggravating factors, or discriminatory juror strikes can unravel a verdict because capital juries must be impartial and properly guided. Habeas corpus, the ancient right, adds another safeguard. After direct appeals end, a prisoner can file collateral petitions raising constitutional errors that were not fully aired or presenting new evidence that undermines confidence in the verdict. The gates are narrow, the deadline's strict, but the writ exists because the legal system knows it sometimes fails. When new DNA results, recantations, or forensic debunking surface, courts may vacate a death sentence or the conviction itself. There is also the reality of plea bargaining. Prosecutors often leverage the possibility of death to induce pleas to life without parole. Critics frame that as letting killers escape death row. Defenders see it as certainty and finality without decades of litigation. The end result, permanent incarceration, may look like mercy, but it is a hard, life-ending punishment that keeps the public safe. Consider a few concrete scenarios. A capital jury never hears that the defendant suffered childhood brain trauma and severe fetal exposure because counsel never investigated. A court later holds the penalty phase unconstitutional, or lab notes proving contamination of key evidence are suppressed, the conviction collapses, or a condemned prisoner develops dementia and no longer understands the reason for the punishment. The execution is blocked until lawful competence exists. Each outcome is lawful, not because the system loves villains, but because it refuses to execute when the legal foundations are rotten. Is there abuse? Occasionally, actors on either side overreach, defense teams filing sprawling, meritless claims, prosecutors stretching for shaky forensics. But the deeper truth is structural. Capital punishment sits on a cliff edge where error is intolerable. Safeguards that look like escape routes are guardrails built to keep the government from pushing someone over that edge without the clearest legal footing. Curiosity to end. Some jurisdictions have paused executions or abandoned capital punishment altogether, citing cost, error rates, and the burden on victims' families of endless appeals. Others retain it but invest heavily in qualified counsel and vetted forensics to reduce reversals. The paradox remains. The better the safeguards work, the more they resemble a loophole to those who see only the headline, not the constitutional architecture underneath. Above, I leave you more videos so you can keep learning law. Remember to leave us a like and subscribe.